What have you made of the testimony we've heard thus far, and whether things are getting easier or more difficult for Trump and his defense team?
This is going to be very difficult for Trump and his defense team. Nice to be with you, Kailey and Joe. This is very difficult for them because there's really not much they can dispute in terms of actual events. And frankly, one of the things that Trump does dispute greatly handicaps his lawyers, I think, in terms of their ability to cross-examine the prosecution's witness and to look credible in front of the jury, because Trump insists that they try this case with one arm behind their back, supporting his lie that he didn't have either of these, sexual relationships. Nobody in the world believes that. And it'd be much easier to cross-examine, Karen McDougal and Stormy Daniels if you could say, well, that's not really what happened, is it? This happened. And, he doesn't have that option. He's in, total denial, just the way he thought, he won the Supreme Court argument yesterday, notwithstanding the fact that there wasn't a single judge who, is going to accept absolute immunity or the impeachment judgment clause. I mean, he just makes stuff up, and it's his truth. But it's a problem for them litigating this.
Well, Ty, there was some remarkable stories from David Pecker on the stand yesterday as a cross-examination today, but he described a series of meetings that he was brought into, including one at the White House that President Trump invited him to in 2017, a meeting that included the FBI director, James Comey, that included the Secretary of State, Mike Pompeo, the Chief of Staff, Reince Priebus, and other high-ranking officials. You were special counsel to the president. Can you speak to this element of the Trump White House? And were you ever in a meeting with David Pecker?
No, I was never in a meeting with David Pecker. I was in meetings, not many, but I was in a few meetings where I was scratching my head going, why is that person here? It was sort of, Trump had all these, compartmentalized aspects of his life: Bedminster, Mar-a-Lago, New York, Trump Tower, The Apprentice. So he had a lot of visitors, and some of them showed up at unusual places.
Well, and certainly there were those who might be less surprising being in a meeting, like those who actually worked for the White House. There was testimony involving Sarah Huckabee Sanders, for example, as well as Hope Hicks. And we actually were speaking to Palm Beach State Attorney Dave Ehrenberg earlier today, talking about the witnesses we could still hear from. And he was like, it's not going to be Stormy Daniels or even Michael Cohen that ultimately are the real zingers. It's going to be Hope Hicks. And I just wonder what you think about the kind of testimony we could see from her.
Well, I think you see people speculating that she's going to do a mea culpa and not remembering this meeting that she was apparently briefly in, or at least long enough to talk individually to Cohen. But I frankly don't think she's going to be as a consequential witness. I mean, think about what happened today. Last night people are going, Ronna McDaniel, oh my gosh, she knows where all the bodies are buried. This is going to be gangbusters. This will be huge. And they introduced 6 emails and had her talk about her familiarity with Stormy Daniels and Karen McDougal, and she was on and off in no time.
Pretty remarkable. What should we be looking for next week when it comes time to issue a ruling on the gag order, Ty? We thought we might get this today, maybe yesterday, but there are 5 more now alleged violations, according to the prosecution. At some point, the judge is going to have to do something here, and I know we're not putting Donald Trump in jail. So what could be the penalty?
So the penalty is a statutory penalty in New York for these events, $1,000 per violation. And then, in terms of secondary, if there are future violations, the judge has discretion to do more. I think it's very surprising, frankly, that this judge has not already penalized Trump, $2,000 or $3,000 for a couple of the violations, because they're egregious, they're clear violations, and it would present an opportunity to explain to him what the consequences of future violations of that type would be. I think every delay that he interposes in terms of making a decision is an advantage to Trump, and those delays would not be afforded most litigants.
Well, speaking of delays, sir, we'd like to ask you about another case as well, one that is here in Washington and that the Supreme Court was dealing with yesterday, or at least dealing with tangentially, this question around presidential immunity from prosecution in the case brought by Jack Smith here in Washington. The court seemed skeptical of this kind of broad idea of community, but even Chief Justice John Roberts was teasing the idea of perhaps sending this back down to a lower court to really tease out what is an official act and what is not. How do you see this playing out from here? How delayed are we talking this trial here in Washington could be?
So if I can go to 30,000 feet for a second here, the reality is the real delay here was the January 6th committee. They did not share their transcripts or witness interviews with the Justice Department for months. Something like 8 months, give or take a month. They had plenty of time to make their ruling, give their findings, make their recommendations, but they had to sit on it because the speaker at the time was adamant that they not issue anything until shortly before the midterms. But for that delay, we'd already be in trial. This has gone from, its first breath to today in 4 months. That's light speed in the legal system, and particularly in the Supreme Court system. I think what happened yesterday, you saw some frustration from Chief Justice Roberts about the fact that the D.C. Circuit, while it issued a ruling that made it very clear that under the existing facts and the existing indictment, there was no immunity. The Supreme Court clearly didn't think that was enough. And not just Roberts. I mean, obviously, that's why they granted cert. They think there has to be a line. They think that they have to craft some guidance for the lower courts in terms of how to apply this in connection with this trial. But I think, as people pointed out yesterday, I mean, almost all the judges, when they tried to be specific about this case, made it very clear they really weren't so much interested in this case, particularly after Sauer, President Trump's lawyer, gave away the farm, acknowledging that virtually all the conduct alleged in the indictment was private acts. So they're not out to help Trump. Not a single thing that they'll write in this opinion will be actually helpful to Trump. The only thing that's helpful to Trump is the delay. And frankly, I think it's a little hyperbolic the way people approach that because, A, it's moving very quickly for a legal matter of this consequence. This is the most important separations of powers case in the history of our country since Marbury versus Madison. It's very difficult to manage that and get it right without going through, some analysis. And it's unfortunate that it will likely, I think, in my view at least, prevent a trial before the election. But it's not surprising given the stakes.
So that would have been my next question, Ty. If this does go back to the appeals court, is it curtains then for this trial, or could Jack Smith still find time to do this even if it was a President-elect Trump?
So Jack Smith could find the time. Jack Smith would try this, tomorrow night in an alley.
Well, sure he would.
Whether Judge Chuck
the time,
right? Whether Judge Chuck can give him the time, in good conscience, that'll be the difficult thing. I don't think we're going to have a bunch of, sending it back down and having it come back up. But I think that it's quite likely that, this will be remanded at some point to her, and to parse the issue of separating official acts from purely private conduct. As I said, the president's lawyer did a good job of that yesterday under the withering examination of Amy Coney Barrett, a conservative. She got him to concede that virtually all the conduct in that indictment is private acts. So it's not really a heavy lift, but she's going to be applying a new rule that that the Supreme Court will provide her and provide to the country for the constitutional analysis required should these circumstances ever occur again.